Your application is premised on the following grounds. That on the 3rd of January this year, the respondents herein went into land parcel number LR number 1159/88 without any color of right or authority from the proprietor, and they started searching for the beacons. And there's reasonable suspicion that they were planning to sell off the land, which is located in Karen, to unsuspecting members of the public. Your Honor, the suspects were arrested by officers from Karen Police Station and were placed in custody at Karen Police Station. After interrogations, there's reasonable suspicion to believe that the suspects are in possession of forged title to the same parcel of land, which they are using to lure unsuspecting members of the public into believing that the title deed is genuine and that the land is being offered for sale. Here in a nutshell, the respondents so far have been cooperating with the investigating officers, which has led to the arrest of other suspects who are purporting to be owners of the said land. Your Honor, within the period that the investigators are seeking for these 7 days, the investigators wish to record further statements to also trace the purported owners of this land. The said respondents will be aiding the investigators to trace other suspects who are at large. Further, the investigations into this matter are quite complex. And the respondents will be aiding the investigators to recover the forged.
By a notice of motion dated 5th January 2022 and supported by an affidavit of Sergeant Leson Schumer of 5th of January 2022. The main prayer is a request that the court holds the 4 respondents at Muthaiga Police Station for 7 days, pending completion of investigations of 4 purported offences against both the state and a complainant. The application is not opposed by the 1st and 4th respondents. However, it is opposed by the 2nd and 3rd respondents through the counsels Mr. Omari and Mr. Shadrach Wambui. In opposing the application, the following main issues arise. Number 1, the request to restrict the rights of the 4 respondents, of the 2 respondents, for 7 days is excessive. In the alternative, the court grants bail or 2 days custodial period. Number 2, since the land reference number is known, the state uses its machinery. It ought to investigate the matter at the land office to determine any other persons who are purported owners of property. Number 3, less restrictive measures should be considered by the court. Number 4, vide 2 cases, Sudi Oscar versus Republic 2020 EKNR and Michael Rotich 2016 EKNR. The defense seeks that the court is persuaded not to allow the police custodial orders as they are subject to abuse. In my determination, I have considered the facts as presented. I have also considered Article 24, 27, and 49 of the Constitution and all other laws as cited by the parties. In the case of Sudi Oscar, the matter was that a member of parliament had violated and committed alleged offences including hate speech, assault of a police officer, possession of firearm, resisting arrest, and offensive conduct. He was placed in custody by the lower court for 7 days. Independently, I have considered the case of Chris Philip Obure versus Republic 2020, Kenyan'S, where Justice Wakiaga James said, the state has a right to investigate offences and use all necessary machinery at its disposal. The rights must always be safeguarded and limited as provided by Article 24 of the Constitution. The question is, are there compelling reasons advanced to detain the respondents? In addition, has the state obtained sufficient evidence to charge the respondents? Article 36A of the Criminal Procedure Code gives the condition on denial of bond. These conditions are flight risk, likelihood to interfere with witnesses, is it necessary for own protection, are there breach of conditions of release. The state explained that the respondents were cooperating well and they wished to interrogate them further. In the foregoing, having analyzed the application by the state, there is no reference to the 4 conditions above. I am therefore persuaded that the respondents can safely be granted bail by the court. The state is yet to record statements and get other suspects. However, the recording of statements and tracing of other suspects should not be placed squarely on the shoulders of the respondents. In fact, this may be deemed as contravening the rights of the respondents. Having analyzed the facts, the precedents, the law, the arguments herein, I find that the respondents will be detained at Muthaiga Police Station for 2 days, ending 11 a.m. on Friday, 7th of January. Thereafter, on 7th of January, after 11 a.m., the respondents shall be granted police cash bail of 30,000 each and shall report daily to the investigating officer. Should they fail to raise the same cash bill, they shall remain in police custody. A further mention of the matter will be on 12th of January 2022 in court number 11.
Application by the state dated 5th January 2022 on grounds that this affidavit, Your Honor, is an affidavit full of contradictions. The state, in paragraph 1, states that the question why the second and third person are before you is land LR number 1159/88. It is specific to that land. Paragraph 7, Your Honor, says the applicant, who is the state, through the investigating officers, want to trace the purported owners of the land connected to the offense and make more arrests. The state knows the land registration number. You know, it wants time to go and look for that purported owner. There must have been a complaint launched by the owner of that land to warrant the state to move to arrest the second and third. The state doesn't know the owner, but it knows the registration number of the land. You're out of curiosity, the state moves further in paragraph 12 of the supporting affidavit. That going by the averments in paragraph 11 above, it would be appropriate to investigate the motive behind the forcible entry, and Your Honor, that is where the bombshell is, noting that it is a property of a prominent leader. This is a property of a prominent leader. And the state concedes that that prominent leader cannot even be mentioned before you. And it says, due to security reasons, I wish not to disclose his name. There's a pattern, consistent pattern. They know the LR number. They don't know who it belongs. But again, they confirm that it is a prominent leader. Because of security reasons, they cannot disclose before this court. Your Honor, my two clients were told that this land belongs to the head of state of this country, the president of this country. And that is the reason why my two clients are being dragged with a lot of fanfare, just because the alleged land belongs to the head of state. That is the information that I've gotten from my clients. Number two, an application for 7 days is unreasonable. The state wants to go and verify a fake title deed. According to the state, already a title deed has been issued. The title deed allegedly is in possession of the second and third person. The title deeds, Your Honor, are a preserve of the land's registry. The state does not need 7 days. To get a search on that land. If it is the land of the head of state, all lands, and I urge the court to take judicial notice that all lands of the head of state are protected by the dreaded GSU company called Receipt. These two small rascals could not gain entry in the property of the head of state. These are mere people who are walking on the road, and they have been dragged before you. And Your Honor, with the fullness of time, these are many of those matters that never proceed, because there is no complainant in this matter. Lastly, Your Honor, the state has sought for 7 days. 7 days is unreasonable. We'll be seeking that the court grants the state in between 2 days, so that these first, second, and third can be released on bail or can be detained for 2 days. And we shall be seeking the court to release the second and third on cash bail. The state has confirmed by itself that they have been very cooperative. They have not run away. They have not failed to assist the police. And therefore we'll be seeking, Your Honor, they be entered in cash bail. Your Honor, I urge the court to be bold and stand firm. Paragraph 12 is aimed to intimidate this court. That this is a property of a prominent leader. The independence of the judiciary does not respect prominence of any leader. Ownership of a title does not respect prominence of any leader. Everybody before you, Your Honor, is equal to the law. If indeed they entered and trespassed into that land, they entered and trespassed the land of an investor. And we urge this court to treat this as any ordinary allegation of suspects brought before you. So, Your Honor, we urge that you stand firm, ignore paragraph 12, which was written to intimidate you. The name of the head of state is being bandied around to intimidate the court, and allow the second and third to be released on bail. Lastly, Your Honor, I'll urge the court to take judicial notice of the latest precedents. Where miscellaneous applications are filed, the court releases the respondents on cash bail, pending the ruling. The case of FKF and Mwendwa, the president of football, he was released pending the ruling. May that also fall on these two, so that they are released pending bail. The state has enough machinery, as Shadrach will